Chief Justice, Associate Justices, may it please the court, my name is Kevin Considine and I represent the appellant. This case involves a lease going back to 1986. And the lease was between the plaintiff landlord and the defendant Byrne, Inc. The lease contained some unusual provisions as it related to liquor licensing in Article 11.24. Those provisions included that the tenant would become a sublicensee of the landlord. There would be an automatic reversion of the liquor license upon the termination of the lease, and there was a prohibition against pledging the license. Those provisions are inconsistent with the regulatory scheme established in Chapter 138.
Didn't the ABC sign off on that lease that had that pledge?
Well, interesting question. The ABCC signed off on the corporate-to-corporate transfer from St. Cloud Corporation to Byrne, Inc. in 1996. The lease was part of the application process, but it's important to know that there are many papers filed in connection with the transfer.
Meaning you think they didn't read it? Is that the argument, that they didn't
No,
read it?
I'm not saying they don't read it. What I'm saying, and this goes really to the negative pledge agreement. What I'm saying is the ABCC didn't approve the negative pledge agreement. The ABCC does not approve negative pledge agreements. There's nothing.
Confused by that.
Right, they approved the transfer that had an anti-pledge provision in a lease.
It had many provisions in the lease. It doesn't mean they approved the financing. It doesn't mean they approved the work conditions. It doesn't mean they approved many of the documents. If you look at the total application that was filed in connection with the corporate-to-corporate transfer, there are many things in there the ABCC doesn't approve. What one has to look at is the final approval that the ABCC signed off on, and all that concerned was the corp-to-corp transfer.
Is there any case law for that proposition, that we look at the final bottom line as opposed to the supporting documents?
Not that I'm aware of, but I'm also not aware of the ABCC ever approving a negative pledge agreement. That by statute, they're authorized to approve pledges for loans.
What's the authority for that proposition that they've never approved a lease within a transfer that has an anti-pledge agreement?
I'm sorry,
can you cite that? How do we know this is,
well, it's sort of like
you've heard trust but verify, right?
It's sort of like proving a negative, though. It's never come up because they don't do it. There's no case.
How do we know that?
Because there's no case law out there interpreting this.
Here we are.
I'm sorry?
Here we are.
Well, the problem is it runs contrary to the highly regulated statutes set up in 138.
Sorry. Are you saying that it was against public policy to enter into the negative pledge agreement at all? That, in other words, well, let me take it back one step. Are you saying it's against public policy, and I don't remember all the corporate names, but I'm just going to call them the landlord and the tenant, just for ease, that it was against public policy for the landlord to transfer or assign or the license to the tenant?
No.
No. Okay.
Well,
so if that's not against public policy, how does it become against public policy to restrict the tenant's ability to do anything further with that license? Because it seems to me that what you're saying is the public policy is that ABCC should have as much control over who receives these licenses, who can use these licenses as possible. And so it seems to me that if the first transfer is not void against public policy, then restrictions on that transfer would also not be void against public policy.
couple of things. First of all, the landlord did not own the license. It's important to note that it was St. Cloud Corporation that was a transferor, or Byrne was the transferee. And what I'm saying is Chapter 138, Section 23, last paragraph, gives the ABCC the authority to approve pledges for a loan. And I refer the court to the 1996 Beacon Hill Civic Association versus Toscano case, in which this court held that a contract between private parties that prohibited the party from applying for a liquor license was unenforceable as against public
Right, but
policy.
that seemed to me that what the court was saying was that it was a void against public policy because it restrained a person's ability to participate in a government process that they might otherwise be entitled to participate in. That's not what happened here.
Well, I think that's a very narrow reading of that decision, with all due respect, because in Toscano, they went further and they cited to the law that contracts that are against public policies established by the legislature are not enforced. Excuse me. And the pledge.
Isn't the presumption the other way in public policy? That it has to be a clear violation of public policy.
I would respectfully suggest what's clearer than the last paragraph of Section 23.
Would you agree that's the standard? And the presumption is that people have freedom of contract.
That freedom of contract is an underlying principle, sure, but it.
All right, would you agree with me that the presumption is freedom of contract in that public policy is an exception, a narrow exception to freedom of contract?
Yes, and what I'm saying is under Section 23, the legislature's grant of the authority in 1976 for the ABCC to approve the pledge for loans of liquor licenses is that exception.
Why is that inconsistent with an anti-pledge? Just because the ABC can approve a pledge doesn't mean that a contract that precludes pledging is against public policy. Again, the ultimate objective is what Justice Wolhogen said, which is the ABCC retains control to approve any liquor license. So both of them accomplish that. So I don't see why they're inconsistent with each other.
Well, the ABCC approved the pledge in 2019. They had the complete record in their files.
They also approved the anti-pledge earlier. So again, they seem to be consistent as long as they get the last say whenever the license transfers.
I would respectfully suggest they did not approve the anti-pledge. They approved the corporate-to-corporate transfer. There were dozens of pages of documents submitted in connection with that corporation-to-corporation transfer. They don't approve everything in there. They approve a limited number of things. And if one looks at,
if you're right that this anti-pledge is something that would trouble them, wouldn't they reject it then? Because again, we have to assume they read the documents submitted to them, don't we? Unless you've got authority for that. I've never heard sort of the argument that a government regulator has signed off on something it hasn't read.
If you look at the approval, they signed off on the corporate-to-corporate transfer. They didn't sign off. There's no mention in the approval process of the negative pledge agreement. It just seems to me.
So your position would be that the ABCC must take some formal action with respect to every document that's been placed in front of it in connection with a corporate transaction about which they've been informed?
No, my position would be the opposite. They don't sign off on everything, and you have to look to see what they did sign off on to see what they actually approved.
That's what I'm saying, that your position is that they would need to specifically approve each individual component of a corporate transaction in order for that to constitute approval.
Well, again, we have to look at the last paragraph of Section 23 that specifically authorizes the ABCC to approve a pledge. And what I'm suggesting is when you have a legislative directive like that, then that takes precedent over the general rule about the freedom of contract. When you read
I'm sorry. But what you're saying is a lot broader than what Section 23 governs. The Section 23 governs the approval of a pledge for a loan. Okay, and so that's an important component here. So Section 23 governs the ABCC, but I didn't hear if you answered Justice Kafka's question, which was mine. It doesn't control private obligations. And so if it's only talking about an anti-pledge for purposes of getting a loan, how do you extrapolate that into the governing of private loan obligations?
As a matter of public policy, the legislature's established, the ABCC has the authority to approve pledges for loans under certain circumstances. And if they assume that authority, then I think that takes precedent over the general rule as to freedom of contract, if that's what Your Honor is asking.
Well, that seems to then be the inverse proposition of Justice Gaziano's point, that the default rule is that parties are free to contract. And if you're going to say that it's void as a matter of public policy, but the provision that you're relying on contemplates the situation that's not here, how do you square that?
I'm not sure I understand what you mean by a situation that's not
But
here.
they're not pledging it for a loan.
It was pledged for a loan.
Yeah, but it's a negative. It's you can't further transfer, right? So they back to Justice Wolahojan's point, you can get it, and all we're saying is you can't further than transfer it. So I'm just struggling to see why that's no good, why you can't do that. And I don't know if you got an answer, if I got an answer to Justice Kafka's question. That's my same question. Why does Section 23 govern private loan obligations in the way that you're saying it?
Because of the pervasive authority given to the ABCC by the legislature to govern all aspects of liquor licensing. And I refer to Toscano, and in Toscano, this court laid out the broad authority of the ABCC when it comes to liquor licensing, cites the Conley case back in 1956. There's a whole string of cases in which this court has ruled that the authority of the ABCC is not to be limited when it comes to alcoholic beverages and the regulation of alcoholic beverages. And what I'm suggesting is specifically as it relates to the authority to pledge the license, that's a declaration of public policy by the legislature. And that takes precedent over Justice Gaziano's question about the default position on freedom of contract.
Mm-hmm.
Is there a definition of licensee in the statute?
Not a direct definition in terms of statutes normally having a Section 1 with definitions, but if one looks to Section 12, it defines what the definition indirectly, it describes what a restaurant licensee is, on-premises license, and if one looks to Section 15, it describes an off-premises license, like a package store license.
So who was the licensee here
So the
under the statute?
The licensee in 1996 was St. Cloud Corp. St. Cloud Corp transferred the license to Byrne Inc. Byrne Inc. became the licensee in 1996.
Okay, for purposes of the statute, or is licensee in the statute referring to who receives the license from the ABCC?
Yes, and who's authorized to sell alcoholic beverages?
Where do you get that last part from? Because what I'm wondering is if licensee in Section 23 means the person ABCC granted the license to, and only that person.
I mean, I think that's clear by the statute, it's clear by the case law. Only licensees are authorized.
Okay, so that seems to run contrary to your argument then.
Oh, I don't believe so. Well,
Why?
quite the contrary. What I'm saying is licensees are very specific. They have to be approved by the ABCC. And they're subject to all the rules and regulations of the ABCC in the statute, Chapter 138. And one of those provisions is they can apply to have their license pledged for a loan. That you can't do it outside, you can't have a pledge outside of that regulatory process. So the pledge is a specific authorization within the entire regulatory scheme of 138.
But what we have here is a contract not to pledge. We don't have a pledge.
Well,
What in
That's
the
what this case is
statute,
all about, the pledge.
sorry, in 1996,
Correct.
the contract, there isn't a pledge that's being approved there. They've contracted not to pledge. So I go back to Justice Gaziano's question about freedom of contract and the idea that it exists unless there's a clear indication from the legislature. So how do we clearly discern that this category of contracts between true private people is not allowed under the statute? Because presumably license holders enter into all kinds of contracts. They don't have to submit every contract they enter into to ABCC for approval. So why is this one clearly precluded?
Great question, because this court in the Beacon Hill Civic Association versus Toscano clearly said that a private contract for a party not to apply for an all-alcoholic beverages license is unenforceable as against public policy. The same principle ought to apply to...
Okay, can you explain exactly why that is, where the court in the Toscano case was very clear that the concern they had was about members of the public participating in front of the ABCC, and essentially the diminishment of the ABC's ability to do its regulatory function if people are secretly being held back from participating. Where we have two private parties here, what's the analogy?
The pledge is a public process as well. One has to have a public hearing at the pledge.
But the thing that you're claiming is against public policy is not a pledge. It's a promise not to pledge.
Yes. And
There's not a public interest in pledges existing.
So let me step back. If one looks at the regulatory structure of 138, it's difficult to pick individual sections and say, well, this is consistent with public policy, but that isn't. You look at the overall purpose of 138, and it's to control who's involved in the liquor licensing industry. There's plenty of case law out there on that. And one of the things they look at is who has an interest in a liquor licensing. And you can look at Section 15A. In the statute, it specifically says one has to disclose who has a direct or indirect beneficial interest in a license. Plaintiffs never disclosed that in this case, yet they claim it was a property interest. So what I'm suggesting, when you look at pledge in Section 23, you have to read that consistent with the rest of the statute, saying the ABCC wants to know who's involved financially in a liquor license. They want to know who has an interest.
The problem with this argument is that they literally handed over the lease in 1996, which contained this provision. And I understand your argument that the ABC's approval in 1996 wasn't necessarily specifically an approval of the anti-pledge agreement, but it was an approval with respect to which they had notice of the anti-pledge agreement.
Yeah, they don't approve anti-pledge.
But the problem for you is you're saying that this is against public policy because there was a secret agreement here not to pledge, but it wasn't a secret agreement.
Oh, I'm not saying it's a secret agreement. It was fully disclosed. And in 2019, when the ABCC approved the pledge, they had that lease in their file. They had that negative pledge agreement in their file. They don't care about that.
Wouldn't the public policy and the reason why a pledge has to be approved is because the ABCC wants to know who has a interest, right? Who's a silent partner, who has an interest in the liquor license, the person who receives a pledge. The anti-pledge is the opposite. There's nobody's going to get a security interest in the liquor license, correct?
That would be correct, yes.
Thank you.
Thank you.
Attorney Kelston.
Good morning, Your Honor. I'm David Kelston. I represent the appellees in this case. I'm going to try to simplify, if I can, just a couple of facts. First, the St. Cloud restaurant was owned and its stock was owned 100% by Nicosia, if there's any confusion. He was also the trustee of the trust, which is a landlord, and oversaw the lease. So any transfer had to be approved by him. it's important to realize, I think, that, well, first of all, we have the lease, and the lease has detailed provisions. It's a lease between sophisticated business entities, and they're represented by very sophisticated counsel, and that's in one of the amicus briefs who identify those counsel. And it was the obligation on the lessee to go get this all approved by the authorities, by the alcohol beverage authorities. And it's important to realize that Tenant Byrne in 1996, Tenant Byrne, Inc. in 1996 is the same entity as defendant Tenant Byrne, LLC, 20 years later. Tenant Byrne, Inc., the tenant, got all of the information necessary to the regulators and got the approval. They were required to do that by the lease, and they did it. And if you look at defendant's brief at page 14, paragraph 2, the defendant admits that the tenant Byrne, Inc. took care of this transaction. And what they were supposed to take care of is making sure that at the end of 10, 20, 30, 40, 50 years of use of this free license, that license would be that the tenant would take action to return the license to the landlord.
Go ahead.
I was going to switch to the conversion claims. So, and if you do have a question about, I would be interested, if you don't mind, could you possibly please turn to the conversion claim and explain both why it's a form of personal property that's subject to a claim of conversion, and also why conversion can occur where Byrne LLC was the holder of the license at the time that the events took place?
Well, conversion requires exercising control over somebody else's property. And we have a lot of law that we put in our brief, and that New England Legal Foundation Pioneer has put a lot of authority in their brief that the license has a dual character, as both personal property and as sort of institutional property. So I think it's pretty clear that in circumstance, it is personal property as between individuals. It's not personal property as between the licensing authority and individuals. The licensing authority can revoke the license if it chooses to, but an individual can't do that. And I think it's pretty clear there's a conversion count here.
Can you address the possession issue? So at the time of these events, you could say that what occurred really was a wrongful alienation of whatever these property rights are, as opposed to a wrongful possessing of something that wasn't
Absolutely right, Your Honor. They were supposed to have turned the license over when the lease ended. Remember, the lease, they had use of the license for decades for free. And when the lease ended, they were supposed to turn it over. They were supposed to go to the regulators and ask for permission to convey it back to Mr. Nicosia or his assignee or his entity.
And are you aware of any authority where the dominion and control that was wrongful and supported a conversion claim was actually an alienation of the property at issue as opposed to a taking of the property at issue?
Absolutely. They maintained control over it. They alienated. They didn't do what they were supposed to do. And this goes to the issue of good faith. If there was any good faith here, Mr. Lesser would have gone to the regulator.
How does Nicosia maintain control over a liquor license that's held at this point by the Byrne LLC at the time of the conversion?
I'm sorry, Your Honor.
He has a future interest in it, right? at the end, in 2026, was it? It reverts back to him.
Yeah,
At the time of the alleged conversion, the license is being held, the restaurant is being run by Byrne LLC, correct?
during the pendency of the relationship, of the lease relationship, the license was under control of and belonged to Byrne LLC. And that didn't change until the lease ended. And Mr. Nicosia never attempted to change it. He never interfered with it. All he asked of the tenant was, be sure to protect the license. We have to protect the license. And that's in the record.
So I'm curious to know your answer to Justice Gaziano's question. At the moment of conversion, wasn't it Byrne's LLC that controlled the license?
Byrne LLC controlled the license, Your Honor, but wrongfully.
I don't,
Because pursuant to the lease and pursuant to the negative pledge agreement, which was within the packet of information that the tenant in 1996 sent to the regulators.
but how does someone who doesn't maintain control over the property that is subject to the conversion claim, how can they assert a conversion claim?
Conversion means, as I understand it, Your Honor, exercising control over. It doesn't mean that you have legal ownership. It probably means you don't have legal ownership. If you did, it wouldn't be conversion. You're refusing to return something to somebody who should have legal ownership. So,
Can I ask about the public policy for a second? When the anti-pledge provision kicks in and it returns to your client, he doesn't have the right to use the license, right? He has to go back to the ABCC to use the license? Because I'm just trying to make sure, to me, the public policy is that the ABCC always has control over who's using that liquor license. So when it reverts back to your client, what happens to ensure that that interest is protected?
you're absolutely right, Your Honor. What the lease calls for, what the negative pledge agreement calls for, and what all the papers before the licensing authorities in 1996 called for was at the end of the lease, the tenant had to petition the regulators to approve return. If Mr.
So your
Les-
client doesn't have an active license once that anti-pledge thing kicks in. He just has the right now to go back to the ABCC, right?
Yes,
Okay. Can I ask then a follow-up question? Because I don't find Toscano the clearest case on earth. Can you help me out with this sentence from Toscano? Where laws are enacted on the grounds of public policy, their uniform application for the protection of all citizens alike is desirable. An agreement to waive their provisions is generally declared invalid. And then here's the part that I don't really understand. But where they are designed solely for the protection of the rights of a private party, a party who may be affected can consent to a course of action which, if taken against his will, would not be valid. Where do we fit in that? Because back to the way you were talking about Pioneer's brief, and this is sort of a mixture of private and public.
dual nature, Your Honor, yes.
So it's a dual nature, but so how does this sentence, which seems to be a key part of Toscano, apply to a dual nature?
I'm sorry, could you say that again, Your Honor? I'm having trouble.
Sorry, Toscano seems to draw a distinction between private property rights, which you can waive, and rights that are more public that you cannot waive.
Correct.
And then both you and the Pioneerists to describe this as a mixture. So I'm just trying to understand, is Toscano was clearly outside this case or not? I understand the key part of Toscano says, we don't want you to waive your right to participate in a public hearing, but then there's this sentence, which I don't really follow.
I think the answer to the question is that the agreement between the landlord and the tenant about return of the license is a purely private agreement. And I think it's clearly the case that it's the kind of agreement that happens all the time, for instance, in commercial real estate transactions. The landlord takes some sort of security, some sort of protection. It might be you can't make an assignment for creditors, you can't go into bankruptcy, you can't do all these things. And if you do, the lease is terminated and all your rights end. And that really is all this is. It's a little more, though, because the license was originally Mr. Nicosia's. So he's saying that's a valuable asset. When the case ends, Your Honor, you may see from the record that Mr. Lesser says everything in the restaurant premises is worth $20,000. And he's trying to sell the license and the premises and the lease to a new buyer for $525,000. That means the only thing of value is the license. And what the landlord says, and he's represented by counsel, and the tenant is represented by counsel, he says, I'm giving you this valuable, you're going to petition the regulators to take this valuable asset. You're going to petition it back. But it's my security. It's my security that you'll fulfill your obligations. It's my security that if you move out of my restaurant premises, I'll be able to have someone else run that restaurant because they'll have a liquor license. So I think that's exactly what has happened here.
Are negative pledges something that you see a lot, or it seems like I can imagine it would be a regular thing that somebody who is leasing restaurant space would want to get the liquor license back at the end of a lease. I don't know a whole lot about this. I'm just wondering if this is an unusual provision or if it's something that you'd see.
Your Honor, there's no evidence in the record about that, but my understanding is, again, you had two very sophisticated attorneys, one who was a professor at Suffolk and the other who is one of the best-known attorneys in Massachusetts today. They decided to do this the way they did it in 1996, which I think was common then. Today, they have management agreements and different ways of handling licenses so that the license never actually changes ownership. That may be a better way, it may not be a better way. But the overall premise is the same. I can't run my restaurant without the liquor license. I can't do it. I'm going to let the tenant use that liquor license. But when the tenant ceases occupying my premises, I still have to have my liquor license or my premises become useless.
Isn't the reason behind this, or part of that proof of that is it's a dollar fee, right?
Yes.
And then it's $1 to get it back.
Yes.
Right? That's the point of it.
It's and you'll see in defendants' papers that they talk about how the license is worth hundreds of thousands of dollars. That's property. Between individuals, hundreds of thousands of dollars, at least as far as I'm concerned, is property. And it's a lot more than $1.
Can you address that argument about Chapter 93A, Section 3?
I'm sorry, Your Honor.
Could you address the argument about Chapter 93A, Section 3?
Okay. 93A, Section 3 says, as I understand it, Your Honor, and we litigated this 2 or 3 times, if you don't break the law, you're not liable under 93A. So if there's an exception under 93A, the exception is you're not breaking the law. So, but you can't, so you can't get a pledge agreement that is in violation of the lease. The tenant had no right to pledge the license. Under terms of property law, they didn't have the power to pledge the license. They pledged the license, and then they said, our breach of the agreement, our pledging the license becomes our defense to the breach of the agreement. 93A Section 3 is to basically say, if the law has said something is legal, it's very difficult to challenge it under 93A. There are cases that still challenge something under 93A, but none of them are remotely like this, where the Section 3 challenge relies on what's clearly action the tenant was prohibited from taking and was beyond the tenant's authority to take because the tenant didn't have the power to take it. So, Judge, I'm ready to talk about 93A if Your Honors don't have additional questions.
I think we're,
But just on this central issue of public policy, just again, it was the tenant who applied for the license from the regulators, and it's very important that the negative pledge agreement was part of the file. It's 4 pages with bold captions, and it tells you not just that you can't pledge the license, but it tells you what the provisions of the lease are, that the tenant's gotten this license for $1 and the like, and they can't pledge it.
okay, counsel, thank you so much. I see your time is passed. Thank you.
Is my time up, Your Honor?
Yeah.
Okay.
Thank you.